So with this, I would now like to kickstart our actual conference today, the first session being on introduction to SEPs and Frand licensing. The session chair for this is Dr. Manveen Singh. Mr. Manveen Singh is an associate dean at Jindal Law School and is an expert of intellectual property law. He also heads the Center for Intellectual Property and Technology Law. And UCL alumni Dr. Singh indulges in intensive research in the field of SEPs and competition. Added to that, he is also an author to numerous criminal law and intellectual property law research papers in a number of national and international journals, along with several book chapters. Okay, so this session on introduction to SEPs in France is from 2 p.m. until from 2:45 p.m. until 4 p.m. with 15 minutes of Q&A session included in that. Dr. Manveen Singh, I would now request to take on the floor for your session, please.
Thank you so much for that generous introduction. I think I should be waiting for the panelists to join me over the next 5 to 7 minutes, I suppose.
Okay, till the time they join, I will also introduce the speakers for the session. Uh, Dr. Manveen Singh is chairing the session. The other speakers for this are Professor Aviroop Bose. He's the professor and assistant director, Center for International Trade and Economics Law at Jindal Global Law School. We then have Dr. Padmavati Manchikanti, Professor, Rajiv Gandhi School of IP Law, IIT Kharagpur. We have Mr. Ashutosh Kumar from Singh and Singh. He's the partner at Singh and Singh. And we also have Mr. G.R. Raghavendra with us, who is the Joint Secretary, Department of Justice, Ministry of Law and Justice. So, Dr. Manveen Singh, you may please just start with your session with your initial remarks or initial points that you may want to share.
Okay. May I please request my fellow panelists to turn on their cameras so that I can see everyone? And then we can, of course, begin over the next couple of minutes. Thank you.
Yeah, Mr. Ashutosh is joining just in a few minutes. I think,
Sure.
Manveen, you can start the session.
All right. Thank you so much. Just a minute. All right.
You may want to introduce your speakers, Dr. Manveen.
Yes, of course. A very good afternoon to everyone who's tuned in for this first session of the conference this afternoon. I have with me my fellow panelists, Professor Aviroop Bose, who's a professor and assistant director of the Center for International Trade and Economic Laws at Jindal Global Law School, and of course, my colleague at JGLS. I have with me Dr. Padmavati Manchikanti, professor at Rajiv Gandhi School of IP Law, IIT Kharagpur, and Mr. Ashutosh Kumar, partner Singh and Singh Associates, would be joining us over the next couple of minutes, and of course, Mr. G.R. Raghavendra, Joint Secretary, Department of Justice, Ministry of Law and Justice. A very good afternoon to all of you, and good to see Raghavendra sir join us for this session today to deliver the special remarks. Uh, Should we be waiting for another couple of minutes for Ashutosh to join, or should we begin the session? I can proceed as suggested by
You
the.
may wait for a couple of minutes.
Sure, sure. Anyway, it's
Sorry for that,
2:41.
the audience. I'm so sorry for that. He's just joining.
Sure,
Yeah,
no problem.
there's some technical issues in
No
joining, so
problem.
please. I think meanwhile, till Ashutosh joins, you can the speakers can give their introductory remarks for the session. You may want to.
Sure. What I'll do is I'll proceed with just a couple of lines regarding the background to the session, and then I can move on to my fellow panelists and invite them on to give their introductory remarks, if that's all
Sure.
right.
Sure, yeah, that's absolutely fine.
All right. Thank you so much. Thank you. So
You can
the title
share
for this.
about your book also, Dr. Manveen. Sorry to interrupt about the book.
Sorry, I missed the first part of your statement. Sorry.
You can, I'm congratulating for your book, and you may just share, give some inputs about the book.
Oh, okay. All right. Thank you so much. I'll do that accordingly. Thank you. So the title for the session today is, of course, Introduction to SEPs and Frand Licensing. And given the depth of the topic, involving SEPs and standard setting organizations and the development of interoperability standards, it is quite possible that a lot of the speakers today, or a lot of the participants rather today, would find themselves in a situation where they are still slowly coming to terms with how exactly this entire system works. How has the jurisprudence evolved over the course of time, and where are we likely heading over the next few years, considering the pace at which technology standards are coming into the fray, or for that matter, the way the Internet of Things has slowly but surely, announced its arrival amidst all of us. Standards have long been considered as the driving force behind technological innovation. And over the course of the past 3 decades, technological standards developed under the aegis of standard setting organizations, or SSOs as we commonly know them as, have played a key role in shaping the modern day communication systems, whether it be Wi-Fi or 3G or 4G or 5G, and the Internet of Things as we see around ourselves in today's date. And central to the development of technology standards, however, are standard essential patents, or SEPs, which are further required to be licensed on FRAND terms. Now, what I have introduced through these 3 or 4 lines are several terms: standard setting organizations, or SSOs, standard essential patents, or SEPs, and of course, FRAND, or FRAND. Now, what exactly are SSOs? What do they do? How are SEPs linked to SSOs? And then where does FRAND come into the picture? These are some of the things, these are some of the questions which we will endeavor to address over the course of the next 55 to 60 minutes. With that, I would first like to call upon my colleague, Professor Avirup Bose, to talk a little bit about standards and standard setting organizations. And then we can, of course, move on to the aspect of SEPs, Frand, and where exactly does the intersection of IP and competition come into the picture, given the fact that Professor Avirup specializes in the area of competition law. So, Avirup, if I may request you to kind of briefly touch on the aspect of standards and what exactly are SSOs doing in terms of developing these standards. Please. Avirup, we can't hear you. Probably you need to unmute yourself.
Sorry, there was some problem in my ability to unmute myself. A good afternoon to all of you. And I just following on to what Dr. Singh just said, talking a little bit about the evolving jurisprudence. I'll come to standard setting organizations and standards in a minute. There was a book that came out or was published in around 2002 or 2003 by the India correspondent of Financial Times in New Delhi, Edward Luce. The book was called In Spite of the Gods. It kind of chronicled how India was poised to emerge at that point of time, the third biggest economy within a generation, without any government help as such, completely industry driven, completely by private actors, without really a lot of government or regulatory help. If I could talk about the last 9 years of the development of a standard essential patents jurisprudence in this country, what Manveen was talking about, that today the fact that several of the devices which we use in our daily life incorporates multiple amount of standard essential patents, and a thriving industry around this has developed without really a lot of help apart from the excellent work done by the Delhi High Court. Without a lot of help, which I mean from regulators, including the Competition Commission of India. Not necessarily their fault. It has been a historical journey over the last 9 years. I hope to briefly touch upon it. Standards are in essential something that all of you know about. The Indian Bureau of Standards have routinely developed certain standardized products that is being used across industries. Extension of that is standard essential patents, which are patents that is used across devices and in a particular industry. One of the biggest examples I keep on giving to my students is Wi-Fi. It's a standardized patent, which essentially means doesn't matter what your telephone manufacturer is, doesn't matter what your internet service provider is, and doesn't matter which state of India or which part of the world you are, you will seamlessly be able to connect to the wireless device or network. That's essentially because there is one standard which has been used or implemented across this industry and by the implementers. The question, therefore, which comes right next, again, from a competition law point of view, is that when a particular sort of patent is given the status of being a standard, it becomes obviously the dominant technology in that field. And therefore, concomitant with that denotation of the standard patent requirement is that the license are given to all willing licensees, and that's a very important term, hopefully, which we'll be able to unravel over the course of this session. Willing licensees on Frand terms, which is fair, reasonable terms. It's called RAND in certain jurisdictions, it's called Frand in other jurisdictions. Essentially speaking, these are terms which are fair, reasonable, and equally applicable to all willing licensees. Non-discriminatory, fair, reasonable, and non-discriminatory terms. Now, there are standard setting organizations, global standard setting organizations. There is now an Indian standard setting organizations also, but globally speaking, it is particularly concentrated in the European Union. United States have its own standard setting organizations, and they, through a very detailed process. Again, Manveen is much more his doctorate thesis is on this area, so he will be able to maybe provide you a lot more details about how particular technologies become standards. And there are a lot of issues there, including certain antitrust and other legal issues in terms of a standard setting process, including quite disputed certain principles that is being followed and later withdrawn by some of these organizations. Coming to India, because I really want to spend the remaining, I do not know, Manvir, how much time I have, maybe another 5 minutes or something of that.
What I can do is maybe we could come back to the Indian bit in about a few minutes. Once I'm done inviting everybody's initial comments, and then we get into the specifics as per the Indian jurisdiction. So we can just go around once with every speaker, and then I'll come back to you again.
That's all right. So I will end by saying that what essentially students and everybody who is listening, who doesn't have a background in this area, standards are essentially patterns which work across industries, given the interoperability of those standards, and it's extremely essential for the development of these industries, because it really goes to the heart of consumer welfare, and which is the standard sort of obligation for all antitrust authorities across the world. But a complexities that appears here is the way the licensing of those standards happen, because at one stage, as Manveen will maybe elaborate, there are issues with certain technologies becoming standards. That is also there. But second, once they become standard, it's only a half battle won, because then those standards have to be successfully licensed to willing licensees, and there's an entire developing jurisprudence, what amounts to Frand terms, what amounts to the process by which litigation and negotiations and in certain stage arbitrage is done in order for these licenses to be successfully reach the hands of the willing licensees. I'll stop there, Manveen, and then whenever you want, I can speak a little bit more on Indian competition law.
Yes, of course. Thank you so much for those initial comments, Avirup. You did mention, of course, about Frand, or in other words, fair, reasonable, and non-discriminatory terms, and the fact that the moment a technology is included as a part of the standard, the buck doesn't stop there. In fact, the most important stage is really the ex post stage, which is when the two major stakeholders, that is the SEP holders or the innovators on one hand, and the implementers or the licensees on the other hand, need to come together, sit across the table, and negotiate licenses to the use of those technologies as a part of the rollout of that standard or the implementation of that standard. On that note, I would like to invite upon Professor Padmavati to talk a little bit about what exactly is Frand and how does Frand feature in this entire system of standard setting at SSOs in the lead up to the licensing of standard essential patents on these so-called Frand terms. Professor Padmavati, over to you.
Yeah, very good afternoon, all of you. Dr. Manveen, Dr. Bose, Dr. Raghavendra, and Dr. Ashutosh, and my good friends, Dr. Chitra and Dr. Sheetal, and many others in this forum. I will be making a presentation on the success difference between.
Sorry to interject there, Professor Padmavati. You need to be a little louder because unfortunately I cannot hear you very clearly.
Yeah.
Yeah.
Okay, is that better now?
Yeah, much better than before.
Okay.
Thank you.
Right. Yeah. Very good afternoon, all of you in this panel. Dr. Manveen, thank you for inviting me for a few initial remarks. I have a presentation, very short presentation on the success difference between a patent and a standard essential patent, and how do we see it today? From the beginning to the current perspective. I'll be presenting that shortly. But quickly to remark on the question, or rather the query that you have posed on what is this thing called Frand? And how do we see it from the point of view of the standard setting organizations? I think the very fact that there are going to be severe issues of what you call hold-ups and holdouts. So today we talk about hold-ups and holdouts. The basis of bringing in Frand licensing is to really look at how do we really look at the contractual part of the entire SEP. And all of us understand under contract law, there is something called good faith in terms of negotiations. And when you're dealing with hundreds of patents, and today we talk about SEPs, it is going to be very difficult to really fix a royalty. And therefore, we're looking at what? When we're looking at the set of patents, we're looking at a movement of an entire set of technologies. Thereby, when we talk about non-discriminatory, what do we mean by non-discriminatory? That today, I'm taking the entire bunch from you at a particular royalty rate, but remember, this is going to be globally implemented. Now, later on, you cannot realize that, okay, I have a great opportunity, so I'm not going to discriminate between who are the people who are going to be implementing. So therefore, non-discriminatory brings in that particular concept. Now, when we're talking about fair and reasonable, well, this is where I would say, shades of what we mean by reasonable is dependent on the SSO. Let me tell you this, and it is negotiated. These are voluntary standards, but they come by consensus. So therefore, what is fixed is again dependent on what is the area we are implementing. Ultimately, we are looking at the commercial essentiality. I'll speak about that when I talk to you about the differences between a patent and an SEP. So, to me, if you say reasonable, it should be reasonable as per the implementation of the technology. Today, we look at interoperability. So, reasonable, taking into consideration the entire set of patents, the holders, the implementers, and a whole lot of third parties are involved. Fair, I would believe, is typically a concept that good faith, good intention must be there. So it's not like you come around and then, so fixing the Frand is actually helpful to avoid what you call a lot of litigation. And also at the end of it, you're looking at the transaction cost to the market should come down. Ultimately, the SEP holder, there is a lot of transaction on SEPs happening, but the market should not suffer. So Frand brings in a kind of an obligation, therefore. And this is something, of course, Frand, you can speak for at least 6 hours, but I'm not going to go into that. There are experts in that. But this is my very simple understanding from the point of view of the entire SEP licensing. And this is a jurisprudence which is going to evolve. There is no specific ballpark figures. Courts have given the lower limit and the upper threshold. There may be a need for revision of that. A revision of that may be required, considering again market. So those things, well, this is just my short deliberation. And I leave it there and speak more when I present. Yes.
Thank you so much, Professor Padmavati. Of course, we'll come back to you for your presentation shortly. Let me take this opportunity to welcome a fellow panelist, Mr. Ashutosh Kumar. And I think it's the right time to call him upon to talk a little bit about what exactly is it that has resulted in SEP litigation, or if we may call it Frand litigation. Because at the end of the day, we are talking about patent licensing, and more specifically, standard essential patent licensing. And as Professor Padmavati just mentioned, that well, SEPs are a little different. And one of the reasons is, of course, because they're going to entail a Frand undertaking, and the licenses are subsequently granted or supposed to be granted on Frand terms. That then raises the question that we see so many cases being litigated across the world, whether it be the European Union, the US, China, Japan, or India for that matter. So, what exactly is it that is resulting in SEP litigation? A quick introductory, set of remarks by Mr. Ashutosh. Ashutosh, over to you.
Thank you, Manveen, and good afternoon, everyone. Manveen, the short answer to your question is that what exactly has led to the filing of so many SEP litigations all across the world is unwillingness of few parties to negotiate voluntarily and take a license and choose to litigate and bargain a deal and try their luck in court of law so that they can get a better deal what they could have gone get in during a voluntary licensing negotiation. And that's in fact has been recognized in so many academic literature in terms of the phenomena of holdout. That has, recently of late, the courts have also started recognizing that parties are creating holdout, and they are not, they don't prefer to take voluntary license, and they prefer to first, litigate and test the validity and essentiality of patents in court of law. And that kind of a behavior or attitude has led to the, increased amount of SEP litigation all across the world.
Right. Thank you, Ashutosh. Well, to be honest, it was Mark Lemley, Professor Mark Lemley, in the year 2002. I'm talking about. So, 2 decades back. The journal was California Law Review.
Yeah.
And the title of the article or his paper was Intellectual Property Rights in Standard-Setting Organizations. A seminal work, if I may call it, in even today, 2 decades later, for anyone who wishes to study about standard-setting organizations, SEPs, the aspect of the intersection of IP and competition, and how exactly are these SEPs different from normal patents, and where do SSOs come in when we start talking about the development of standards? A comprehensive work. And 2 decades later, we are at a juncture in India where conferences like this one today are growing fast and thick in terms of discussing the aspect of Frand, SCP licensing, and of course, standard-setting organizations and how do they do their work in terms of using these patented technologies or incorporating them in the development of standards and subsequently rolling out standards that are to be implemented no matter what company is it, as long as they are manufacturing a standard compliant product. It could be a Samsung smartphone, could be an Apple smartphone, or your Oppos, Vivos, and Xiaomi's of this world. At the end of the day, a 5G phone means the technologies are pretty much going to be consistent across the board. Now, on that note, I would like to again go back to, if I may, and Avirupa, I'll just come back to you, considering that Professor Padmavati has a presentation that she's prepared. So, if Professor Padmavati be allowed to kind of share her presentation first, and then Avirupa, I'll come back to you to talk a little bit about the competition aspect regarding standard setting. So, Professor Padmavati, if you could take a few minutes to run through your presentation, and then we can probably pick it up from there and then go on to our other fellow panelists. Thank you so much.
Sure. I think, am I made the co-host because I need to share? Yeah, okay, I can present it now. I guess.
You can, ma'am. You are made the
Yeah.
co-host.
Okay, okay. So let me just quickly go to my window. Are you able to see my slides? Are you able to see my slides?
Ma'am, slides not yet, but we can of course see your screen. So you probably need to, put forward your presentation slides.
Yeah, how is it now? I put it in the slide share mode. Or maybe let me share it again. Huh?
Yeah, please.
I think let me stop sharing and share it again. I'm sharing my screen, so that should be fine, right?
Yes, I think so. As long as we.
Or is the entire screen okay? Let me do that.
Yes.
I think now it should come up. Okay, is that visible now?
Yes, of course.
Okay,
So if you could go in the full screen mode.
Yeah, right.
Yes, perfect.
Okay. Thank you, Dr. Manveen, and also my co-panelists for allowing me to go first. So I will take about roughly 8 minutes. That's allowed. My job, the job that was given to me, is to define what are the basic differences between a patent and a standard essential patent. Let me tell you, I thought that the job would be a bit easy for a patent teacher, but when I ended up making a table, I found it adequately difficult. I'll come to that as I move on. Okay, so first let us begin with the understanding of where is this impacting us. I think that fairly many of us are aware that the greater the interoperability of many systems. Today, we see standard essential patents essential. And going on the note of Dr. Manveen, yes, Mark Lemley has written a fantastic article. What is essential of standard essential patents? I'd refer that because I appreciate that paper because there's also data in that paper. It is supported by evidence as well. I'll just take a very simple example of a USB. That's something that all of us are aware. We shift between different devices using an USB. And today, USB is also bringing in several new functions. For instance, if you look at USB 3.2, USB-C, these are just not delivering data, but they're also delivering power and data. So that's something which is interesting. So something which has been developed simply to bring in connectivity with a simple interface, 1994, we're talking about a patent, a US patent that was covered with the basic aspect of exchanging data. If you look at the figures of the patent. So this is an industry standard, and this industry standard helps us to implement it across devices. So a standard is essential for us because we're looking at implementation across a wider area of applications and systems. Now then, we understand standards, but what are these standard essential patents? So that means these standards are covered by patents. That is a genuine, simple definition. But then there is an aspect of where we call it essential, which is the middle part of it. So I happened to download this again, this PC magazine of the last month, and I was looking up what are the more recent developments in relation to USB, and just to track how far the progress is happening. But we are day to day developing standards. So now the question is, many of these standards are backed by technical developments, and many of them are covered by not just by a bunch of patents, but by several hundreds, and in many cases, several thousands. So those which are essential for the implementation of the functions of the USB are essential standards, patents. That's about it. So we're talking about when the initial USB development started. If you can look up, I've given this particular site, 7 companies participated in it. They have a workshop, they have a laboratory. So standards are pooled together, and from there the development starts. Okay, as I move on, I'll explain further. So here you're looking at voluntary submission. Then out of consensus, we are looking at what are the set of technologies that are necessary for the implementation of a particular standard. Now, these may be covered by granted patents. They may also be covered by patent applications. That means pending patent applications may also be a consideration. Well, this is just an example for you on how a standard document is prepared. So what is a standard? It is essentially a documentation which provides a detail about what are all the technologies, who are all the people disclosing those technologies, where are the revisions to that technology, and what is happening on the current perspective of introduction of certain products. So this is just an example to illustrate to you that particular aspect. Then we come to if a very simple definition of SEP has to be taken up in a common parlance, patents that are necessary requirement for complying for a standard are nothing but an SEP. Now, interestingly, if SEPs are disclosed, then you need to have a definition for SEP also in any particular technology development. So I went and looked up what happens on the USB end. So obviously you have an adopters agreement in which, look at this part of it that I'm showing to you, necessary claims. These necessary claims are what? Those which are the participating technologies either covered by patent or patent applications. I've just highlighted some part to you. Now, what is this entire USB? It's about, it is about the development in terms of the port and the implementation. That's it. It's very simple. This is a simple illustration for all of us, but this involves a lot of iterations in relation to the technology, looking at it from the point of view of implementation. Okay, so the entire standard development is not a one-day process. It is a normative process, and it is arrived by consensus. So therefore, what goes into the initial part of it, so when a SEP holder submits the technology, You are submitting the entire set of technologies with the general scope of it. Later on, you cannot say that, look, I have submitted 100 patents, in that only 10 are relevant. So be it. So when we look at the entire licensing aspect of SEP, we see a lot of what you call difficulties of both parties. I will put it very simply, not taking any particular side. That's because somewhere obligations in relation to transparency, obligations in relation to good faith negotiation are possibly missing. The other aspect of it is also about the gray area of technology. Today, we realize that maybe 10 patents are essential to the technology. Tomorrow, we may need another pending patent application also to be part of it. Now, the question is, the status of that pending patent application will change through the prosecution at the patent office. What happens as the outcome of that also has a bearing on the standard. And of course, it is by negotiation, so therefore, consensus is a requirement. Okay, moving on. So, what is an SCP and what is not an SCP? It is not so very simple to define just by the definition of an SCP, because today we have moved into understanding essential for what? Essential for the technical specification which I showed to you, or commercial essentiality is also a requirement. Many instances, commercial essentiality also has become an essential part of the entire SCP dialogue. So, I'll not take much time. Let me move on. Okay, so this is a policy of the ETSI where we're looking at what is the essential IPR. And this is one notion. In terms of what are the different IPR, how do we look at that IPR coming in the form of a machinery, in the form of a product, in the form of processes and methods. And wherever you see those which are necessary for implementation of a practical outcome, I would say, whether it is a product or a system, those shall be considered essential. Okay. So, yes, I think there are speakers after our session and as well as within who are going to talk about standard setting organizations. All I would like to say is it is good that we have standard setting organization. Otherwise, we would have had more chaos. That's because the standard setting organizations are bringing together the holders and the implementers. So I'll not touch upon the other aspects of it, but I'll also throw a little light on where are the issues with respect to SCP that we see today. First is disclosure. I think people who understand competition law understand information asymmetry is a huge problem, not only for SCP, even generally in patents as well. We do see. So information asymmetry, to what extent do we have information asymmetry is a question that we need to ask. Now, there's been a lot of discussion about patent holdups. I think patent holdouts is what we are seeing as the prominent litigation that's coming up, because the value is being realized, and obviously that is where we see an interest. And of course, royalty, determining the base royalty is very interesting, the way the courts are coming up. I would believe that a very succinct academic work in this area is warranted in terms of how do we really look at post-implementation of the judgment. How do we see the implementation of the royalty that has been defined? And of course, you have seen a lot of anti-suit injunctions in this area. So it is all about negotiations. It is all about the ability to gather more. Arbitration is something which is useful, but we need to see going forward what happens. Okay. Now, quickly, that I talked to you about the definition from the point of view of organizations. Now, let me bring in the pronouncements from the courts.
Professor Padmavati, sorry to interject. Since we've already taken 10 minutes for this.
Okay, I'll just wind up. I have just 2 slides. I'll quickly wind up
sure.
the next 1 minute.
Yes, please. Yes, please. Thank you.
This slide is only to give you an instance of the very important case of Microsoft versus Motorola, where we talked about. I'll move on because we don't have time. This is a place where the court has now considered several of these points, which are marked now, as an important basis of determining the upper and the lower limit of royalty. And of course, going into the core aspects of SCP and what SCP are. I'll not go into it. It went for very long. There was a diversity action and all of it. And then finally, we had the judgment I'll just take up another. There are many other cases. We've known of a lot of cases, but I'll just bring you to this case, which I think most of you are aware of, the Phillips versus the Bansal case of the Delhi High Court. Again, here we're talking about the prevalence of or acceptance or the relevance of standards beyond certain jurisdictions. This is where the court dealt with that particular aspect as well. When the defendant pleaded that, look, this is not a standard announced in India, which is not the case. They did not bring in enough evidence to, mount their challenge. In any case, it went in favor of Phillips. I'll skip this in the interest of time. And yes, of course, we have the 2021 interdigital versus Yomi. So we continue to have a lot of uh, uh, I would say, elaboration of the aspect of SEP on several fronts. Just leaving it at that. Well, this is a table I thought I would make it, but I don't think I was very successful. I will be refining this further. But what is the essential difference? I'll close it with that. SEP is for an implementation of a standard. A general patent need not be. Pooling is a requirement. SSOs are necessary involved. Of course, private standard setting. Sometimes there's also governmental standard setting. I'm not talking about that. Declaration process of the surrounding aspects of the SCP is also a requirement in standard setting, which is not the specific requirement in the case of normal patent, except for know-how licensing. When to valuation is much more complex. Technological essentiality and commercial essentiality are two notions that are clearly coming up. And if you look at the judgments of Microsoft versus Motorola, interdigital cases, Ericsson cases, courts are also looking at the perception of the market and the valuation of that and accordingly fixing it. Royalty stacking typically we don't see. Most importantly, implementer in the case of a normal patent has options elsewhere. But in the case of an SCP implementation, you need to necessarily choose those set of patterns. So you cannot violate that. So that's just the part of it. Of course, I'm still working on this. I would believe that it's not so very easy to. It's easy to bring in individual characteristics, but comparing them across may not be in toto. So I just be very humble on that. Well, looking for a standard. Now the question is, we know what is a standard rainbow. Who are the SCP holders? Today we know them as these colors. But what about the interface between violet and indigo? What about the interface color between green and yellow? What happens to that space? So that means SCP holders and implementers have still a long way to go, where we see technologies which are patent pending, technology which are not necessarily covered by patents. How do we see those working in the entire SCP? So I believe we still have a lot of work at hand. SSOs are improving their work beyond. This is just a very brief glimpse of the entire thing, and I'll be willing to take questions. Thank you so much.
Thank you so much, Professor Padmavati, for that elaborate description of SEPs, and I really found that last table quite interesting, to be honest. Personally speaking, because that is something which really comes in handy when you are actually talking about SEPs and the difference between SEPs and non-SEPs with with someone who's not really that hands-on with this particular topic. So we will wait for you to kind of build a little bit more on that table, and maybe the next time around we see a more advanced version of that table. Thank you so much. With that, I'll go back to my colleague and fellow panelist Aviru. Since we are, of course, in the Indian setting at this point in time, and we, of course, are looking at how these terms have evolved. So, Avirup, Professor Padmavati talked about interdigital Xiaomi and, of course, the Philips versus Bhagirathi Electronics cases. I would, want to ask of you as to where exactly is, this entire aspect of SEP licensing or standard setting in the Indian context headed, or what is the present situation, and where are we heading? Where can you see this entire situation heading over the next few years? Over to you. Avirup, you need to unmute yourself.
Manbeen, I think you should speak with the organizers because they have disabled our right to unmute. So there's a lag of time because they have to unmute us. So maybe that they can correct at their end.
You
So
are
that we
given
can.
the rights, sir. We just gave you the rights. You can
Okay.
unmute and mute
Yeah,
yourself.
yeah. I have also written that to you on a chat, private chat.
Yeah,
So,
that's-
Manbeen, I know I do not have a lot of time, but let me very quickly look at the last 13 years and divide that into like two broad areas. One is the, because the term is Frand, which is can be broken down into reasonable, fair on one hand and non-discriminatory on the other. And there has been a trajectory of cases which can be grouped, in my opinion, into two heads. One is the 2013 Ericsson's dispute before the Delhi High Court and CCI, that is the Ericsson versus Micromax case. That is obviously has been written a lot about. It is quite 9 years old now. This is classically speaking a determination of the appropriate royalty rate. That was the entire the dispute at hand. On one hand, Ericsson said that you have to pay us a percentage of the value of the device on which our chipset is being used. On the other hand, Micromax argument was that you should only charge us just for your chipset technology, not for other accrual value that a device gets because of intermingling of other technologies. Now, this kind of dispute went before the Delhi High Court on a jurisdictional issue. Delhi High Court, in one of the most progressive decisions, I would say, kind of settled the dispute between intellectual property disputes under the intellectual property laws of our country, particularly Patent Act and the CCI, kind of providing the jurisdiction to CCI to look at these issues emerging out of abuse of dominant processes. Now, although that kind of discussion hasn't been resolved yet. The reason is, unlike as my previous speaker was showing us on the chart, Professor Padmavati, we do not have yet a decision from a regulator kind of saying what would be the equivalent of Georgia-Pacific factors for a country like India. Even the Phillips case, which Professor Padmavati cited, if you go through the decision, you will see the Delhi High Court kind of ultimately ends up saying that the Frand rate charged by Phillips is an appropriate rate because the defendants have failed to show that Phillips is not charging Frand term. That is different from saying what would be the standard or what would be the formula, if you will, of the royalty rate for a country, which is more a country of implementers than standard essential patent holders. And that's a very important point of view, looking at the larger macroeconomic picture of a country like ours. So that is one area which has remained a developing area. I am really hopeful that the CCI at certain point of time will come up with some sort of answers. Interestingly, the 2019 amendment, which is still pending, and a recent decision of the CCI on Oppo technologies kind of was also hinted on this fact that now, under the 2019 proposed amendments, the exception that was allowed to patent holders under Section 3 would be applicable for under Section 4, which essentially means that dominant patent holders will have a right of certain types of exclusions which are reasonable in order to protect the integrity of their patents. Now, we have to also see how that plays out once the amendment comes into play as far as the standard essential patent litigation is concerned. Coming back to the more recent developments, which I think again Professor Padmavati hinted at, which is the development between InterDigital and Xiaomi. Now that again is an extremely important area, Manveen, because it goes at the heart of how licensing and judicial procedure works in this regard. Most of the cases, including the Xiaomi case, that has come before Indian authorities are what is termed by many practitioners as vexatious litigation. These are litigations which are deliberately brought before competing jurisdictions to force licensees to come onto the table. And here, the Xiaomi case is another example where it is the first or one of the first cases where the Delhi High Court agreed to order an anti-suit decision, which essentially was a way of preventing Xiaomi and InterDigital to kind of go back and forth between the court in Wuhan and the Delhi High Court. So there has been certain developments in both the core issue of what royalty rate determination should be. There has been certain advancements made, including the decision of Delhi High Court in 2016, where Delhi High Court incorporated a lot of the principles of litigation or principles of suit proceedings from the German federal court's Hyundai decision into the 2016 Delhi order. I can go into those details if I have time, or if we can get back to that maybe in some questions. But when I say, or when I began my discussion, I said that developments in this area has been in spite of the gods or in spite of regulatory hell, is precisely to touch upon this point. That in spite of today our country being an emerging technology sort of nation, we do not have a lot of clarity. The Delhi High Court has done its job in a lot of way, but we do not have a lot of clarity from the judiciary, in the sense from regulations as well, regulatory bodies as well, as to how A, royalty rates should be fixed, B, what sort of understanding should be between willing and unwilling licensees, C, what type of rent-seeking behavior or what sort of infringement actions can be brought across several jurisdictions which are legitimate and which are predatory in nature. So there is some development, but still this is primarily an industry-driven and a voluntarily sort of practiced, sort of emerging with voluntary practice. Before I quickly end, my last point, which I have not seen develop in Indian literature at all. As you said correctly, that this standard setting process is not a linear process. It doesn't begin on one day and end on the other. Even during the standard setting process, as you must have come across and researched quite extensively in your book, there are several antitrust issues that can be involved. For example, there could be a buyer cartel, minimum price fixing, where groups of buyers who are also voting members of these standard setting organizations can include in predatory behavior in order to lower royalty rates for inclusion into a standard. But we haven't seen a lot of those literature come out. Of course, we do not have those issues before the regulators yet, but eventually, and I'm hopefully there will be more clarity. So yes, there has been this 9-year journey, which has been progressive on the right direction. The Delhi High Court seems to be particularly in favor of standards essential patent holders. However, the CCI has a lot of work on their hands, which they have not yet delivered, in my view.
Thank you so much, Avirup. This actually kind of raises a few questions regarding what exactly is required to be done, especially in the Indian context, and when we are talking about the Indian courts, considering primarily that most of the SEP litigation has been concentrated in the hands of the Delhi High Court, and all the decisions that we have talked about, or all the decisions we keep on getting to read every day, are emanating from the Delhi High Court, which then would allow me to go back to Ashutosh. And Ashutosh, you have 5 minutes, and I'm sorry for that, to address 2 questions. My first question to you is, we've talked about Frand, we've talked about SEP litigation. My simple question is, what is the basis for the Frand defense in the court of law or for the enforcement of SEPs? Is it patent law, as it is for normal situations or for a normal patent? Is it contract law? Is it competition law? Or is it any other law? That's one. Second is, Avirup did talk about, cases being decided by the Delhi High Court. And of course, the CCI was also involved, in quite a few cases involving SEPs. Now, my second question to you is, what really has been the outcome of these cases once the court has said that, well, whatever rate you've charged is Frand or is not Frand, or whatever offer you made was Frand in the first place or not? And if it was not, then what is required to be done? And if it was Frand, then the so-called implementers, what are they supposed to do then? Are they supposed to pay some money in some escrow or pay directly to the SEP holders? So these are the 2 questions. First, what is the basis for SEP enforcement? And second is, what really is required to be done at the end of SEP holders or implementers once the court has said or has decided on whether a particular rate that was quoted was Frand or was not Frand? 5 minutes.
Yeah, so Avirup, to answer the first question, whenever SEP litigation is it start as a pure patent litigation. The right which generally a SEP owner enforce is a patent right. Under Section 48 of the Indian Patent Act, they file a suit. The moment the defendant enter appearance and raises a defense of breach of Frand, so for the first involvement is of patent law. The moment the defendant raises a defense of breach of Frand obligation by the SEP owner, there the contract law kicks in. And till the time the court decides the matter finally, these are the two laws which have role to play in SEP and Frand litigation. So these are the two legal bases. And why the contract law, why the breach of Frand is a subject matter of contract law is because the implementer or a defendant in a SEP suit is in the capacity of a beneficiary of a contract between SEP owner and a standard setting organization. So SEP owner gives a commitment to the standard setting organization that you accept my technology as a standard, and whosoever is willing to take a license from me, I'll give them license on fair, reasonable, and non-discriminatory terms. That's a contract between me and SSO for the benefit of implementers. So the implementers can enforce that contract either as filing a standard suit for breach of contract, which Microsoft did in US against Motorola, or raises as a defense for breach of contract in a SEP infringement suit. So these are the two legal bases. As far as the role of competition law is concerned, that is still sub judice in India. After Justice Bakru's judgment in Erickson versus CCI, that order is under appeal. And because I'm involved in this matter, so I won't comment upon the role of CCI and what would be the role of competition law. But what we have seen globally, especially the Unwired Planet judgment in UK, the court there seems to suggest that the competition law role is basically can only come into picture when a civil court, who is competent court of jurisdiction, holds that there is a breach of Frand obligation. Now, whether that breach has impacted competition in the market or not, that may be or may not be subject matter of competition law, but that's something which we'll have to await the outcome of appeal which are pending before the Honorable Delhi High Court. Now, coming to the second aspect about the kind of ultimate relief, if suppose a court come to the conclusion the rate which were offered were Frand, or the rate which were offered were not Frand, what will be the consequence of such kind of a finding? In case suppose SEP owners' contentions are upheld by court and the court says that yes, the rate which you offered, the terms which you offered were Frand and the defendant's unwilling licensee, then the jurisprudence which has developed so far suggests that the injunction will follow. And in case suppose the court comes to the conclusion that the SEP owners behave in an unfriendly manner and the terms were not Frand at all, then in that case the court has the discretion to withhold the injunction and to deny the injunctive relief. So these are the two consequences which may follow after a final determination of the case. However, as far as this escrow arrangement is concerned, that is something which is subject matter of interim relief or pro tem relief, and that is flowing from the Frand protocol, which European Court of Justice clearly defined in Huawei versus ZTE judgment. After interpreting the ETSI API policy, they laid down a kind of obligations and counter obligations for both the parties. So, as per the Frand protocol, a CP owner will have to initiate the process of contacting the implementers, making an offer, and making its intention clear to negotiate and execute a license. And then the counter obligation is on the implementer to immediately revert and to say that to express his willingness to take a license. And in case the CP owners makes an offer, then the implementers will have to make a counter offer. And in case parties are not ad idem on the aspect of rate or terms, from that point of view, where the counter offer of an implementer is rejected by a CP owner, from that point of time, the implementer has an obligation as per the Frand protocol to start making some kind of interim security escrow deposit. Now, in fact, as far as I remember, the Munich District Court has
Ashutosh, we can't hear you. Ashutosh?
You have access, Mr. Ashutosh. I think there is some technical glitch from his
Yeah.
side.
I'm not sure whether he is able to hear me, but I cannot hear him.
Yeah, his video is also not there. It's
Is visible but not audible.
Sorry.
Yeah, Ashutosh, we lost you for the last about 30 seconds.
Okay, so I was on the point of in escrow arrangement. I said
Yeah.
that escrow arrangement is more flowing from the Frand protocol, which was first discussed in Huawei ZTE case by Court of Justice in European Union. And they laid down that the four-step test describing the obligation and counter obligation of both SEP owner and implementer. First, SEP owner has to contact, then the implementer has to show its willingness to take license. Then the SEP owner has to make an offer and explain how infringement is taking place, and then implementer has to make a counter offer. And the day the counter offer is rejected by SEP owner, from that moment, implementer has to make some kind of interim security arrangement, either in escrow or BG or some kind of a bank deposit, or directly deposit with SEP owner, subject to counter bank guarantee. Now, Munich District Court has come up with a guideline how to implement this Frand protocol, and there the practice which they followed is that the defendant implementer will have to first make a deposit in court, and with that deposit receipt, after only that deposit, they can file a defense in the suit. The similar practice is being followed in India. In so many cases, SEP cases, the courts have asked implementers to make interim deposits. So it's more from Frand protocol. And it's a part of contractual obligation of SEP implementers.
Right.
So I hope I answered both the queries.
Yes, of course. Thank you so much. Avirup, 1 minute.
No, thanks to Ashutosh too. This is what I was trying to say. This is a lost opportunity from the Indian judiciary, including the regulatory branch. These are precisely the answers, the questions that you asked, and the reply that Ashutosh gave. A lot of these are based upon best practices from European Union. A part of that has been incorporated in the Delhi High Court decision, as I mentioned. But this is really a lost opportunity in my view. I do not know why either substantive procedural policies or procedural sort of protocols. I really do not know why the courts haven't taken opportunities. There has been 3 substantial decisions and numerous interim orders. They're in the right direction, but still it lacks the type of clarity that you see in any of these particularly these European decisions. So that's my kind of suggestions. That when you get an opportunity, including the orders that came out in the last 2 years, Phillips case as well as the Xiaomi case, I mean the interdigital case, those were opportunities where the courts could have provided some sort of informal guidelines, which they haven't, which keeps on back in this loop as to what would be the best practice and what would be the ideal things to go, borrowing up from jurisdictions that is not particularly like those of an economic nature as ours. That's what I wanted to kind of.
Right. Thank you.
In fact,
Yeah.
Sorry, just to add what Avirup just mentioned, he's right that there are so many cases which are being litigated before Delhi High Court, but there's as far as the final order is concerned, there is only one judgment so far. But the trend which we have seen in my practice of almost 9 years, right from Ericsson cases till date, the trend which we have seen that the moment implementer realizes that or sees what is writing on the wall, they tend to settle. So when parties decides to settle, the court can't say that no, I have to give a judgment. Or so that's the reason maybe that why the courts have not given any final judgment in so many cases. But having said that, in fact, the Delhi High Court taken a lead, and the patent rule and IP rule which they have drafted and those have been notified. If you read those rules for the first time, any statute in the code, if you see, refer these terms SEP, Frand. And that, not a single statute in India refer these terms, not even Patent Act. So it's a Delhi High Court rule which for the first time has referred to these terms. So the court, because of its rich experience from past 10 years of SEP litigation, have kind of provided some guidance how to adjudicate these kind of cases.
Thank you. Thank you so much, Ashutosh. Of course, These are things on which definitely there's plenty of scope for the Indian judiciary and of course the Competition Commission of India to come in and kind of help lend a sort of a helping hand as and when required. So more on that probably maybe during the Q&A session. For now, I would like to go on to Mr. Raghavinder to deliver his special remarks with respect to this particular session. Sir, over to you, please.
Namaskar, good afternoon, Vande Mataram, and happy to join this elegant and elite panel on standard essential patents. Basically, I'm known as a copyright man, but coming to patents, there are the two areas, whether it is standard essential patents or patents and access to medicines. These are the two areas where I always love to read or discuss or research. Thanks to the way Professor Padmavati ji has started and best inputs given by Mr. Bose. And in fact, some of his comments are totally in agreement with him. Of course, my friend Ashutosh is there, my longtime IP community friend. And coming to the chair, Mr. Manveen, nice to meet you after a long, long time. So, what is the problem? With my experience of policy making and intellectual property law, I burnt my fingers to take best practices. I'm talking about in 2014, around 2015, when this issue of SEP was coming, and early litigation may be happening at that time. So, first and foremost, a couple of people in the policy making, we thought there is no exclusive provision in the patent law. Neither guidelines nor rules totally satisfy. When we began the process of national IP policy in 2016, when the think tank was constituted with the blessings of Honorable PM Modi, and it was implemented by the then Commerce Minister, now Finance Minister Nirmala Sitharaman, the task was given to me. So my advice to the honorable members who drafted this policy, apart from various things thankfully included that need to be taken forward, the SEP was one of the suggestions to ask them to concentrate. But unfortunately, they avoided direct mentioning of SEP policy. They simply mentioned something like, licensing practices or conditions that may have adverse effect on the competition will be addressed to appropriate measures, including a regulation of anti-competitive conduct in the market by the Competition Commission of India, which Avirup Bose was mentioning about. So initially when Professor Padmavati ji was mentioning about what exactly a standard and standard essential patent, a patent which introduces a standard that becomes an essential, when they declare the patent as an essential, whether they go to ITU or HC or any other standard, SSO or SDO, that is the other name, Standard Development Organization or Standard Setting Organization, they have to be very sincere. If they don't go and announce their patent as a SEP, they hold it up and see what is happening in the market, then only I will enter and make stashes of money which we happen to see through television news channels which are showing from Kolkata, SSC scam. Multiple kind of money they want to make by this behavior. That's where the IP and competition law interface comes, which Aviru Bose was mentioning about. So they have to mention this. And another issue was rightly mentioned here about asymmetry of information. Even though they expose their patent, they announce it as standardization patent, and they make it tied with these Frand licensing. so-called fair, reasonable, and non-discriminatory. But what are the guidelines for that? You know, the very Frand itself sometimes a big joke. The way it is implemented, the way people, litigation is happening, not only in India, also in Europe. You see the Motorola case or Samsung case where the decisions are being given. But beauty of the European system, they just like the safe harbor which the DMCA Act America introduced for the digital copyright online platforms, they introduced the kind of safe harbor by the European Commission for these kind of IP competition issues for the SEP licensing. So licensee will be getting a kind of safe harbor. This the great Delhi High Court has not thought about. Of course, I do appreciate join the team which praises them and join the team again, which raise their sincerity that they always at the side of the patent owners. That is evident through various judgments. Whether vexatious litigation happening or sham litigation happening, this has to end when there is a proper policy there. Of course, DPIIT did come out with a kind of paper in 2018 that was left and right criticized. But one good thing happening after Delhi High Court decision, the best of the best policy decision was taken, which Avirup was mentioning about 2019 amendments to the Competition Act, which recognizes the IP right holders' right, and that could not be taken forward, but that lapsed. But now that is being reintroduced as a Competition Commission Amendment Bill 2022, now in the Parliament, with disruptive things happening and suspending the members, not allowing the House to happen. Hopefully, this will see the light and the bill may get passed. And coming to this issue, we need to address this at policy level as well. What I understand, the way our friends have mentioned, if you see the entire telecom sector in India, so where were we in 2014? The two mobile manufacturing units. And then we moved on to 2G, to 3G, to 4G. Now we are in the hub of 5G, and experts are all talking about 6G. What happens? A friend company of our Ashutosh comes up with a kind of SEP that is essential for making your 5G to function your mobile. Now India has 2,000 mobile manufacturing units. India is a now second largest unit. It's all because of the Make in India policy, which led to introduction of national IPR policy in 2006. The next policy should help this 2,000 unit manufacturing unit to function. In the latest data says by 2026, India will be having 1 billion smartphone users. At present, 750 million mobile smartphone users out of 1.2 billion total mobile users. So the players, we started our policy initiative with Make in India, now slowly moving towards Atmanirbhar Bharat. So how many units owned by our Indians? Just like, getting the pieces and assembling in India, just like iPhone, Samsung, or Xiaomi doing or manufacturing totally in India, still all these are foreign units. Imagine 100% Indian unit, Atmanirbhar Bharat unit comes, then it needs SEP licenses. Then the hold up happening because and various reasons, that royalty stacking is happening covertly or overtly. No, you can't blame the licensee who is seeking Frand license always. There are mistakes done by the owners as well. That's what I understand. What I gather from outside this panel discussion and including this panel discussion, we need to make a policy which functions in a gives a kind of win-win situation to the SEP owners and SEP users as well. And then, of course, competition Commission Competition Act amendments has to help the interface between the competition law and IP. You just can't say that because there is a civil case, then only Competition Commission has to enter because the jurisdiction of the Competition Commission is sacrosanct. Whenever monopoly is misused or abuse happens or dominance happens, they have to come. Their decision, especially that the Ericsson not following the Article 6 of the ETSI regulations, it is clear from the Competition Commission decision. Of course, the matter may be sub judice because as a policymaker, I see the consumer interest should not be defeated, and the contribution of these industries to economy, whether the owner of SCP or user of SCP, should be maximum. Both should be happy. Then only then economy flourishes, and then we all be happy. That is very, very important. So one of the ideas I floated when I was in DPIIT was amend the Patent Act, include exclusive provisions and how the SCPs have to be dealt about licensing mechanism and all that. With my experience of introducing amendments and lawmaking, so sometimes even I think about how to introduce Frand licensing, which is similar to compulsory licensing in the patent. And also giving a kind of guidelines how it should be done, how SSO have to function, how this has to be implemented. The general guidelines, but with giving a freedom to function to SSO or the SCP owner or the other people. And another
Sir, sorry to interject. We've already exceeded the time, so if we may bring in the Q&A
yeah, sure.
time now. If you could just take about a couple of seconds to just wind up. Thank you so much.
Finally, I want to say that concealing SCPs are information asymmetry, because one company seeks Frand license, he doesn't have any comparative rates. So what kind of 10 other Frand licenses given by the SCP owner? That is totally unfair. What kind of fairness or reasonable or non-discriminatory license he is giving if he is not providing information to them? And then last point I want to tell you, the joke of imposing because you give one SCP license and you force him to pay the royalty of the percentage of the price of entire mobile device. If your mobile device is 10,000, the royalty rate is 10 rupees, let us say. The same company has other advanced device with the 20,000 mobile. Do you think that they have to pay 20 rupees for that rate? For the same SEP, which is using, there is no innovation in that technology. Same technology, SEP patent, which he is using for 10,000 mobile and 20,000 mobile. And if he pays the percentage of the end mobile price rate, then it is really unfair. What kind of Frand license you are giving. So I know there is no justification for royalty stacking, asking them to pay third party 50%, these kind of rates, and also the device based license rates should not be there.
Thank you so much, sir. With that, of course, we've touched on every single aspect of standards in SEP licensing, starting from what exactly are interoperability standards, moving on to standard-setting organizations, and of course the aspect of SEPs, and in between we've talked about and we've touched on the issue of information asymmetry and the lack of disclosure, if that is alleged to be there, and of course licensing on Frand terms, and then the intersection of IP and competition, and where exactly are those anti-competitive concerns arising out of standard setting, and then finally, of course, the entire aspect of SEP licensing in the Indian context. But I'll just like to conclude by saying, the following: that in the entire ambit of standard setting and licensing of SEPs, there are different stakeholders involved, and of course, the two most important stakeholders are SEP holders and the implementers, and then we move on to, of course, the consumers like all of us. What is extremely important is for there to be a balance. We could go on and on arguing about what exactly is wrong on one side and what is wrong on the other side, but what definitely calls for attention at this point in time, not just in India but across the world, is a need for balance between the rights of innovators on one hand and the implementers on the other, because it cannot just be allowed to be lopsided just because of one particular entity or one particular stakeholder's interests. And I'll, as requested by the organizers, I'll just take about 20 seconds to share my screen. What I was actually going to talk about was my uh, my uh, book, but I think I cannot really share my screen here. But what I can definitely talk about is that I've just come out with my maiden book on SEP licensing and standard setting organization. The title of the book is Standard Setting Organizations IPR Policies. It is published by Springer Nature and is available for ordering both as a hardback version and Kindle version on Amazon and on Springer's website. And lastly, what I would like to actually say, even if it is a coincidence, is the fact that I've actually touched on every single aspect of standards in SEP licensing in each of the chapters of my book, starting from the history of standards, from the Ice Age hunters up until today's date, and then moving on to disclosure practices, then Frand and SEP licensing, and then the intersection of IP and competition, and finally, of course, the aspect of SEP licensing in the Indian context. So, just in case anybody would want to read further on these aspects that we've covered over the course of these 60 minutes, you may please, purchase a copy for your reference. Thank you so much. With that, if we can just take questions, if there are any, with respect to our session.
Yeah, so we have received as organizers quite a few questions. The first question is for Mr. Ashutosh. How does FRAND licensing and global standardization assist in tech transfer and in enhancing competition? Ashutosh, if you could please.
Yeah, in fact, I think the answer to this question is in the comment of Dr. Raghavendra when he mentioned that how post 2014 the Indian mobile phone market has flourished and competition increased, and we have so many players in India, and that's the testimony of benefit of SEP and Frand. And if I know, if you all recall, it's I believe somewhere in December 2013 that a few implementers went before CCI and said that the Indian telecom market is in danger because here's one SEP owner, he's making unreasonable offer, and there's a royalty stacking, hold up, and everything. Indian mobile phone market will finish. Please stop him. And now we are in 2022. India is second largest telecom market in the world. There are 5 to 6 new players who have entered in the market. In fact, it's over competitive. What a lot of people say, the Indian mobile phone market is over competitive. So that shows the kind of the baseless allegations which were raised, or kind of red flags which were raised. Baseless, I won't say, because the matter is sub judice. It's for the CCI and for the Delhi High Court to decide ultimately. But The red flags which were raised in 2013, I believe the empirical evidence which we have now in 2022 suggest contrary. And that is the one of the reason, maybe because this hold up and royalties taking, these are two very attractive terms or very fancy expressions. But what is the genesis of these two concept or doctrine? The genesis is not some kind of a problem which were existing in the industry. The genesis was one academic article written by, again, Mark Lamley, as Manveen mentioned initially. Mark Lamley and Carl Sherpue, they authored an article, I believe, if I'm right, in 2007. And there they discussed for the first time this problem of royalty staking and hold up. They were not discussing as if that this problem exists in the industry. They were saying that because of the nature of SEP, this problem may arise. And they said that's why there should not be any injunction for SEP and for SEP related litigation. And they said that withholding or denying injunctive relief may not create a problem for SEP owner and still balances the right of both SEP owner and implementer, because there is something called treble damages in US. However, that article was taken out of context and out of US jurisprudence, and throughout the world, especially the competition authorities started tom-tomming that article and discussing this concept of hold up and royalty stacking. But that article was written in the specific context of US law, because the authors there mentioned that some kind of a pressure or incentive is necessary for the implementers to incentivize them to take license. If not injunction, there should be something called treble damages. Now, treble damages is not the relief which exists all over world. It's something which is peculiar and unique to US. So hence, that kind of academic issue led to creation of another problem, which is called holdout, which is judicially recognized, which is there in Justice Bliss judgment in Unwired Planet, where he said that the holdout exists in the industry. And that's why the concept of unwilling licensee and the courts now saying that injunction is one of the important remedy, and it exists in SEP cases as well. So that's my response. I hope. Is there any follow-up question on this?
We can't hear the organizers. Maybe you need to unmute.
Yeah. Sorry. We are running short of time for this session, so I think we'll have to close this session. Thank you. It was a wonderful discussion. Thank you all the speakers for giving your valuable time and inputs. Okay, and we would now proceed to our next session on global jurisprudence on SEP. Thank you.
Thank you.
Thank you so much.
Yeah. So, okay. So